WhatsApp is still on my dashboard. Have it switched over.
Good morning, ladies and gentlemen. Thank you so much for coming. So this is the event called Justice for the Environment, the ICC's role in Ukraine and on the African continent. I am Wendell Mokia, and I'll be the program moderator for the day, so you'll see a lot of me. I'm also going to be the person who's going to tell you to stop presenting or give you an indication of when you need to stop. But I'm very friendly, I'll be in a friendly manner. So this is a very important event. We are fortunate to have the Ukrainian delegation here. There's about 7 or 8 people from Ukraine come and speak about environmental crimes, but then also we have Prof. Glazewski and others to speak about environmental damage or environmental crimes more generally. So hopefully we'll learn a lot from today, looking forward. And I'll now hand over to Zinka and to Angela to briefly introduce, and then we'll start with the speakers. We're starting a bit late, so we'll have to cut a bit on some of the presentations, but we're going to see how it goes. We have to finish one. And then we have a coffee break. I'll also announce the coffee break. It should be around 11:30 or 11:45. Thank you so much.
Good morning, esteemed colleagues, distinguished speakers, and participants joining us in person and online. It is my pleasure today to welcome you here on behalf of the African Centre for Transnational Criminal Justice and the Global Environmental Law Centre, of which I'm the director, and also just in general the Faculty of Law and University of the Western Cape. It really is lovely to have you here. We are gathered here today at a time when the devastating consequences of war on the environment demands urgent legal and policy responses. Armed conflicts don't only cause profound human suffering, but also wreak irreversible damage on ecosystems, water sources, food security, and biodiversity, often with generational consequences. While international law has long recognized the protection of civilizations in war, our discussion today asks a critical question. Can and should we do more to protect the environment as an independent victim of war crimes? Today's program brings together scholars, practitioners, and experts engaged in pioneering work on prosecuting environmental crimes. The destruction of the Kakhovka Dam in Ukraine represents a particularly pertinent case, one that calls for the full weight of international law to be applied under Article 8.2 of the Rome Statute, which criminalizes international environmental destruction during armed conflict. This case, however, is not only about Ukraine. It has global implications for how we enforce environmental protection in war zones, including on the African continent. For Africa, the intersection of conflict, resource exploitation, and environmental degradation is deeply entrenched. From illegal mining, fueling armed groups, to deforestation and water contamination caused by military campaigns, environmental crimes often go unpunished. Yet today's discussion will highlight whether an evolved approach by the ICC to environmental crimes presents new opportunities for accountabilities, whether in the context for oil spills in Nigeria, illegal deforestation in the Congo Basin, or for the destruction of critical ecosystems in conflict zones across the African continent. Conversations around the ICC shift in how it approaches environmental crimes is necessary and timely. However, legal and evidentiary challenges in prosecuting such crimes does remain a challenge. Questions of jurisdiction, evidence collection, and political complexities in international justice will shape whether environmental law or war crimes will receive the recognition it deserves. I just want to touch briefly on 2 aspects, and then I'll head over to you. I think that beyond the role of the ICC, we should also think of the role of international environmental law in armed conflicts. While laws of war like the Geneva Convention and the Rome Statute offer some protection, other treaties such as the CBD or even the UNFCCC and the Ramsar Convention establish obligations on states to safeguard systems even during crises. And we should think about how this may apply in times of war. These frameworks lack enforcement mechanisms, however, and they raise important challenges on how the principles and foundational structures of international environmental law can play a role or not. The United Nations General Assembly's recognition of the right to a clean and healthy and sustainable environment in 2022 signals an important shift. reinforcing the need to treat environmental harm not just as collateral damage, but as a fundamental rights violation. And then lastly, we should also think about the push for ecocide as an international crime or a fifth crime in the Rome Statute. The independent expert of panel for legal definition of ecocide has defined it as an unlawful or one-time acts committed with knowledge that they will cause severe and either widespread or long-term damage to the environment. Surely we can fit that into current definitions in the Rome Statute regarding environmental destruction. The destruction of the Kakhovka Dam in Ukraine, which has led to catastrophic flooding, biodiversity loss, and threats to water and food security, presents a clear case where ecocide could be applied. And if this is successful, we can apply this in other contexts too, particularly in Africa. So as we embark on today's discussions, I encourage us to think boldly about how we can advance environmental justice in the context of war. How can legal frameworks, international and domestic, better evolve to protect natural ecosystems? What lessons can we learn from current ICC prosecutions? And most importantly, how do we ensure that environmental crimes are not just treated as peripheral concerns, but as core violations of international law? Thanks.
Thanks a lot for the introduction. My name is Vinka Kachun. I'm a research fellow at the Center for Sustainability and Transitions at Stellenbosch University. I'm also part of the Ukrainian Association of South Africa, an organization that brought today a Ukrainian delegation from two organizations. One is Ukraine-based organization Truth Hounds that specializes on documenting human rights violations and environmental violations during the war, and the other organization is international organization Project Expedite Justice. Those two organizations have conducted documenting at the territory of Ukraine of destruction of Kakhovka Dam, which was already mentioned by Angela, as well as violations of nuclear safety and security at the Zaporizhzhia nuclear power station. Fortunately, the war in Ukraine that started in 2014 and increased to the full-scale invasion in 2022 provided new challenges to documenting war crimes, and also provided more examples to potentially documenting environmental war crimes. There are currently over 140,000 documented war crimes, and Kakhovka Dam destruction and occupation of the Zaporizhzhia nuclear power station is also one of those cases that has been documented and reports have been submitted. I hope that we can build a little bit more collaboration around documentation about classification of those crimes, because our international legal system is not ideal, and on the continent there is a number of examples when environmental law was championed. We always praise Pelindaba Treaty, which until now provide probably the best example of nuclear safety regulation, not only for the continent but globally. There is significant expertise and experience also from multiple war crimes that exist on the continent. And we hope that by building this collaboration between experts in South Africa and in Ukraine, we can ensure more justice for environment globally.
So much, Zinka and Angela. There's just a comment online that the audio is not loud enough. Slaksha, do you just want to check if we can increase the audio from here, or is it because you're not speaking into the audio of the laptop? I'm not sure.
Maybe it's that person's device.
Okay. You can also check your devices at home if you can just increase your volume there. But please let us know if you can't hear us. So we'll have to start with the first presentation, and it's a privilege to invite Dr. Miyiwa Adigun, a reader in the Faculty of Law at the University of Ibadan in Nigeria, to come and share about the crimes against humanity, crimes against the environment in the African continent. So you are welcome to share your presentation with us, Dr. Adigun.
Good morning.
Yes,
Can you hear me clearly?
we can. Thank you so much.
And may I share my screen? It appears sharing the screen has been disabled.
Technician will just check. Not able to share it here, we'll just continue as is. Okay, you can share, see if you can share now.
Okay, I think it's open now. Just give me some few minutes.
Thank you.
Just a few minutes, please. So,
The aircon fine here, everybody.
okay, because I'm trying to open it, but I couldn't get it here. Just a few more minutes, please. Okay. Hmm. Okay. I'm finding it difficult to connect with my Mhm. Okay. If we cannot get it, let me proceed with my presentation. Okay. Uh, good morning once again. Muyiwa Adigun is my name. I'm a reader in law in the Faculty of Law, University of Ibadan, Nigeria. I'm starting my presentation with the introduction. Crimes against the environment appears to be as old as humans. And the first possible example occurred among the New Guinea island tribes. Now, after having defeated their enemies, they will occupy their lands and cut down all fruits on the lands to prevent them from coming back to it. Actually, they were not measures taken as booties, but they were just meant to prevent the enemies from coming back to that land. A more documented example was the conquest of the North African city of Carthage by the Romans. The Romans covered the whole city with salt to destroy the means of livelihood of the inhabitants. You can imagine that. In 1573, the Spanish Netherlands governor, the Duke of Alva, destroyed all the countryside in Holland. And this was just for a purpose, to prevent rebels from being able to depend on the food stored in the countryside. And between 1069 and 1070, William the Conqueror launched a series of attacks in the northern part of England, where villages were razed to the ground, crops and livestock destroyed, and thousands of men and women were slaughtered. It is now popularly known as Harrying of the North. Then in 1938, during the Second Sino-Japanese War, the Chinese dynamited the Huanyuanku dike of the Huanghe Yellow River to prevent the Japanese army from advancing into their territory. And what was the consequence? Several thousand Japanese soldiers were drowned, while hundreds of thousands of civilians were killed. Then during the Second World War, the Nazi troops flooded about 200,000 hectares, which was about 494,000 acres of Dutch farmlands with seawater. These farmlands were about 17% of all the farmlands in the Netherlands. Imagine that. And in 1960, the US sprayed the vegetation used by Vietnamese soldiers as cover with herbicides. The name of the herbicide was Agent Orange. 18.8 million gallons of pesticides were sprayed, covering 20% of the total forest of South Vietnam. In fact, after some years, it was discovered that Agent Orange could affect DNA. And then women started having abortions. And then some children were born deformed. Then in the then Yugoslavia, the war led to the destruction of nearly all the national parks in Yugoslavia. And of course, in 2023, the Russia-Ukraine war led to the destruction of Ukraine's largest dam, Kakhovka. And this led to a disastrous flooding in which thousands of hectares of land were submerged, dozens of human lives were lost, and thousands were displaced. So what all these events show is that the destruction of the environment is as old as humans. Now I move to the next stage, which has to do with the ICC and crimes against the environment. Article 2B4 of the Rome Statute stipulates that, I'm quoting now, intentionally launching an attack in the knowledge that such attack will cause incidental loss of life or injury to civilians or damage to civilian objects or widespread, long-term and severe damage to the natural environment, which will be clearly excessive in relation to the concrete and direct overall military advantage anticipated. Now, this is the only provision that criminalizes the destruction of the environment, and it simply means that it can only be prosecuted as war crimes. But to obtain conviction is going to be extremely difficult. First, the attack must be launched intentionally, and the person launching the attack must be aware the attack will incidentally lead to loss of life, injury to civilians, or damage to civilian objects. So you must definitely have that intention. Secondly, the person must have known that the attack will cause widespread, long-term, and severe damage to the environment. Look at that. Widespread, long-term, and severe. Not even all. That means all the three must converge. This is practically impossible to prove. Thirdly, interpreting the words widespread, long-term, and severe in this context is inherently difficult. These terms are very, very nebulous. And then fourthly, the harm must be in excess of the anticipated concrete and direct overall military advantage. This requirement is very similar to military necessity as a defense. But take note of it. Military necessity has always been a defense. So adding this clause to the definition of the crime tends to make prosecution even more difficult. Now, since prosecuting the crimes against the environment is onerous, other possible options is for the ICC to prosecute the crimes as genocide, crimes against humanity, aggression, or as a distinct crime. Now, genocide has been defined as the commission of certain acts with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such. There are three probable scenarios to criminalize environmental harm as genocide. The first one is that the perpetrator intended to destroy a whole or in part, a group, and the deliberate destruction of the ecosystem formed an integral part of this plan. In other words, the perpetrator deliberately destroyed the ecosystem so as to destroy a group in whole or in part. The second scenario encompasses situations where someone wants to destroy a group in whole or in part without intending to destroy the environment. But the environment is nonetheless destroyed in the process. And then the third scenario involves instances where a genocidal intent is imputed because a person is reckless as to the consequence of his or her action, resulting in the destruction of the ecosystem and the group in whole or in part. Now, to find someone guilty of ecocide in the second scenario is not that difficult. But to find someone guilty of ecocide in the first scenario, and to the extent in the third scenario, that may pose some problems. What the above scenarios indicate is that finding genocidal intent may be somewhat difficult, at least as the law currently stands. Now let's look at prosecuted crimes against the environment as crimes against humanity. Now, what this implies is that Article 7.1 of the Rome Statute comes to apply. According to this provision, crimes against humanity is defined as murder, extermination, enslavement, deportation, etc. So to prosecute crimes against the environment simply means the acts or the conduct being prosecuted must have been part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. Then in prosecuting crimes against the environment as aggression, what it means is that customary international law and Article 8b of the Rome Statute apply. Article 8b is yet to take effect. So under customary international law, aggression involves the massive use of force, a manifest and flagrant violation of international law, together with animus aggressionis, resulting in military occupation. So what this implies that if crimes against the environment must be prosecuted, it simply means there must be the intent towards aggression, and then military occupation must necessarily be the outcome. Now, Article 8b of the Rome Statute criminalizes aggression, which by its character, gravity, and scale, constitutes a manifest violation of the Charter of the United Nations. Now, acts of aggression include armed attack, invasion, and bombardment. Now, the difference between these and then under customary international law is that there may not be military occupation. At least this is one clear difference. So that means if you bombard or you invade, and then the environment is destroyed in the process. Together with the fact that the attack must have the character of violating the Charter of the United Nations. And then in terms of gravity and scale, it must be manifest. But one thing with Article 8b is that at the time it was being negotiated, nuclear weapons, biological weapons, or chemical weapons were in contemplation. So what if this thing was committed, but none of these weapons was used, not nuclear weapons, not biological weapons, or chemical weapons? So what happens? Then let's now see how crimes against the environment can be prosecuted as a distinct crime. In 2021, a group of experts defined ecocide as, I'm quoting now, unlawful or unwanted acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Now, this definition emphasizes the commission of crimes against the environment during peacetime. If you look at prosecuting crimes against the environment as genocide, there must be some reasonable measure of violence. Crimes against humanity, there must be some violence. War crime, of course, there must be some violence. And of course, aggression, there must be some violence as well. But with this definition, it simply means during peacetime, it can be prosecuted. Then it also addresses some of the threshold in prosecuting crimes against the environment. While initially under Article 8 of the Rome Statute, we have severe, widespread, and long-term. Here now we have severe, either severe or widespread or long-term. So that means if it is severe, or as an alternative, if we have widespread or long-term, then of course it can be prosecuted. But one thing is that the Rome Statute is yet to be amended to take cognizance of these new developments. So let us now look at the ICC crimes against the environment and Africa. Why the ICC can prosecute crimes against the environment as war crimes, genocide, crimes against humanity or aggression, other crimes against the environment such as trafficking in hazardous waste, illegal exploitation of natural resources and oil pollution, which are important to Africa, are not within the competence of the ICC. Of course, it can be argued that maybe they can also be prosecuted if it is amended or if it is prosecuted as maybe war crimes if there is war. Of course, there may not necessarily have to be war for this to occur, or maybe as crimes against humanity or genocide. So some of the problems we have highlighted, we also apply. Yes. And so the basic point here is that the ICC cannot prosecute these crimes: hazardous waste, trafficking hazardous waste, illegal exploitation of natural resources, and oil pollution. And all these crimes are very important to Africa. Then another side to it is that crimes that are of importance to Africa are often committed by corporations, multinational corporations. And it appears that corporations cannot be prosecuted by the ICC. So how then can some of these crimes be prosecuted? Then it simply means Africa has to take the gauntlet. The first thing that African states may have to do is to strengthen their domestic criminal justice system so as to be able to prosecute crimes against the environment that are of importance to them. And this actually is going to be in line with Article 17 of the Rome Statute on complementarity principle, which says, except a state is unwilling or unable, that is when ICC will intervene. So then African states need to take credible ownership of their criminal justice system. The another one is that African states may have to enter into treaties with one another to transfer their criminal jurisdictions. Of course, this has been in existence, treaties where one country or one state we agree to transfer criminal jurisdiction to another has been in existence before. So it can be applied here in relation to crimes against the environment. So those to whom the criminal jurisdiction is transferred can serve as agents to those who do the transfer. Then the third point, with respect to what Africa can do for itself, is that African states may have to strengthen regional courts, like ECOWAS Court and East African Court of Justice. Maybe this is the time that South African leaders may have to think of reviving the defunct SADC tribunal, at least for a new purpose now, to prosecute crimes against the environment committed in the southern part of Africa. And then, of course, African states have to create African criminal courts. This court may also serve as their agents in prosecuting crimes against the environment. Of course, that one is on the pipeline. There are so many problems with it at present, but it is not within the scope of this paper to address that. But at least it is imperative that African criminal courts should be created. And then all these crimes against the environment that are important to Africa can be prosecuted. And so, conclusion, what is my conclusion? Crimes against the environment is as old as humans. The ICC can only prosecute the crimes as war crimes, but the threshold is extremely high, and the possibility of successful prosecution is slim. The ICC may also decide to prosecute the crimes as genocide, crimes against humanity, or aggression. Each of these approaches is fraught with its own challenges. While the ICC may adopt any of these approaches, crimes against the environment that are of importance to Africa can hardly be prosecuted by the ICC. Therefore, African states may have to strengthen their domestic criminal justice system, enter into treaties to transfer criminal jurisdiction to one another, strengthen regional courts, and of course, create the African Criminal Court. Thank you for listening. That's my presentation.
Thank you so much, Dr. Arigun, for your detailed presentation and taking us through some of the challenges faced with prosecuting environmental crimes. Thank you so much for setting the stage. We will now be hearing from Prof. Jan Glazewski, and he is an emeritus professor at the Institute of Marine and Environmental Law at UCT here in Cape Town. Presentation going online. Presentation. Hello, everybody. Happy to be here. All that to see, I'm sure. I'm grateful to Angela and to Trinka for putting this together. Angela is the director of this little institute here, Global Environmental, what's it called exactly?
Global Environmental Center.
Exactly, that's the one. And it's recent and it's forging ahead. Watch that space. And wonderful that Trinka initiated this. Now I feel a bit of an imposter. I retired 5 years ago. I'm out of touch. I live in the country, 2 hours drive away. And so why did I come here? Why did I agree to talk here? I was asked to talk about particularities of environmental law. I wasn't sure what that meant. Decided to change that to suit me to principles of environmental law. But I'll tell you the real reason why I'm here. Not only because I'm a great admirer of the Ukrainian people and their tenacity, but more particularly because I have a direct ancestral connection to Lviv, to Western Ukraine. So quickly, and I know time's of the essence, I want to tell you that my grandfather and my father was educated in Lviv. My grandfather had a house there and he had a country house. And when World War II broke out, I'm a Light Lomiki. I was born in South Africa. A Light Lomiki is late land. I was born late from my parents. My parents were newlywed when World War II broke out. And much like what's happening now, they left in a hurry, ended up in South Africa. But my grandfather stayed. And he said, I'm not leaving my country, which was then Eastern Poland. And then the Russians arrived, echoes, and like all landowners in the district, they were executing them. And so my grandfather was marched off to the forest to be executed. But the people that worked for him said, don't shoot him, please. He was good to us. And I think that those people were Ukrainians. That I owed an ancestral debt to the Ukrainians for saving my grandfather. And he lived till 1960. Never saw his 4 sons, my father and his 3 brothers, until he died in 1961, and he's buried at Wyszykowska Cemetery. But that's just a personal background. Thank you, Wendell, for tolerating that. Now, as I said, I'm an imposter. I'm going to try and speak quickly. Shouldn't be here because there are far more expert people here than I to talk about what we've just heard from Dr. Avida, Nigeria. I'm going to give a broad overview
of the principles of environmental law. The big point is that international law very much shapes domestic law, and the two kind of talk to each other, and that's very, very important point to note. So the principles of so in my career, I worked for 30 years at Institute of Marine and Environmental Law at UCT. When I started, there was no environmental law. There was international law, and the environment was a textbook that I found in those days. But there was something called the Rio Summit in 1992, long before some of you were born. And that really set the pace, or set the foundations of environmental law today, both domestic and international. And of course, I can't summarize. How do I go forward? One forward. Okay. Well, let's just press that. So at the Rio Summit in 1992, sustainable development was put onto the map as well as a result of the Brundtland report. This is all history. But it's an important history because what is happening here, international criminal law, is the beginning of a whole process. I'm talking about the beginning of environmental law in 1992, as far as I see it. Sustainable development was the cornerstone. They developed principles, the Rio Declaration and other conventions after that. These principles that I've got up here: intergenerational equity, environmental assessment, prior informed consent, precautionary, common but differentiated responsibilities, that's to do with climate change. All of these developed over from international conventions, so-called soft law. Just this. Just push it on one. So, thank you. So I was fortunate to be at the right place at the right time, because we got a small group of us got involved with the South African Constitution, where people were talking about all kinds of other rights, the right to education, healthcare. But a couple of us were talking about environmental rights, and we got a clause in the South African Bill of Rights in the Constitution in 1994. We're the second country in Africa to have something about the environment. Anybody know who the first one was, the African country?
Namibia.
Namibia, yes. Namibia, are you from Namibia?
I read your book.
So Namibia included something in 1990 when they got liberation from South Africa. They included a directive of principle, in the policy section of the Constitution. We went one step further, included environmental rights in our Bill of Rights. And next, please. I'm happy to see that almost in the same period, 1996, Ukraine, is this all valid, this constitutional clause? Yeah. In 1996, Ukraine, is almost amazing how it echoes what we've got. Everyone has the right to an environment that is safe for life and health, and to compensation for damages inflicted throughout the violation of this right. And this is exactly what's the basis of what we're talking about today. And next slide, please. And so I'm moving quickly. I'm talking about the interaction between international and national law. A lot of these principles, sustainable development, is in our national law, the NEMA, or the National Environmental Management Act, where sustainable development is defined. We've got a number of principles, there's about a dozen. And I'm just highlighting two here: the polluter pays principle, the precautionary principle, state the custodian of natural resources. So this is all incorporated into our domestic law. I don't know if it's similar in the Ukraine, if they have a domestic act, but we can chat about that over coffee. Next slide, please. So South Africa has a common law system, a Roman Dutch common law. There's the English common law. And this is touching on the law of delict, or what in English law is called tort law, suing for damages, what our Nigerian colleague was talking about. And in our law, just to come back to basics, there's like five requisites to have a successful civil action. I'm not talking about criminal law now, but there's similarities. For a successful civil action, you need to prove an act, which is obviously the case said must be wrongful. What is wrongful must be contra bono mores. There must be fault. And it can be, generally people don't go out and purposely damage the environment, but they're negligent or there's collateral damage. And the test there is foreseeability. So clearly what is happening around us and what we're talking about is negligence in the form of foreseeability. The real challenge is, this is one of the requisites of dealing, is what type of damage is recoverable and how do you quantify it? How do you quantify damage to the natural environment? If you crash into my car in the parking lot, there's damage, and that's easy to quantify. What's my car? Either one, what is my value of my car before and after it was damaged? There's a second one. How much will it cost to repair it? Put it back to, that's how you quantify damage. But how do you quantify environmental damage? There's a whole new discipline of, I'm saying news in my life, in my career's time, of environmental economics to quantify damage to natural systems. So you've got to show that that's value, and that's a real challenge, which have to be researched further, I guess, in the case in point. And lastly, there's also the very difficult thing of causation. Causation is also very topical in climate change. There's a lot of litigation now, and it would be interesting to pursue how they treat causation there, because does that carbon emission from that factory cause my crops to be damaged? It's very difficult to cause to causality. So that's a huge challenge. Moving on. I didn't know we're going to have, this is our statute, and it does have, it fortifies the common law by specifically stating, it's a very long section in NEMA, section 28. Every person who causes, has caused, or may cause significant pollution or degradation of the environment must take reasonable steps to prevent such blah, blah, blah. And if they don't do that, then the authorities can step in and then recover the costs from whoever did that. So that's in our domestic law, just giving, concretizing, and it goes on this section, but obviously I can't go in here. Next slide, please. So I'll also talk about the African context. I didn't know there was going to be a previous speaker who actually very eloquently talked about in Africa generally, and all I thought of the very vivid incident in the early 2000s of Shell oil. You should Google this. It's just amazing, all the damage, the pipeline oil spilling from that. And this case, this is a settlement where in the second bullet point, the pipeline was operated by Shell Petroleum, a subsidiary of the oil giant Shell. 3 years after the oil spill, Shell had not cleaned up the spills. And at the end of the day, the last bullet point, in 2014, 4 months before the case was due to be heard, the case was settled for £55 million. Each of the 15,000 claimants was paid over £3,000. So after I prepared this slide, I thought I should actually rather be talking about another case of not in Africa, but off the coast of Puerto Rico, where there was a major oil spill, and I can't remember the name of the case, the name of the ship, but there was a major oil spill. It's in my book, if you've got it. There was an oil spill, and huge oil spill, but it caused major damage to a mangrove swamp. Now, a mangrove swamp is very valuable ecologically because it takes away the pollutants in the area. It's hugely valuable if you speak to ecologists. But it's a swamp. It's got no market value. People will not buy plots there to be near the sea, or a hotel won't be built there. So how do you measure the environmental damage? And in that case, an international case, there were two kind of options. Either we count all the amount of bugs and the branches and we see how much the market value. That was one option. And the second one was how much would it cost to restore it? But they battled with this, and they eventually settled for an amount. But just a very good illustration of the difficulties in quantifying environmental damage. Okay, next slide, please. So we already had a speaker on this. I didn't know how much detail you're going to go to. As far as I know, no environmental crimes have been prosecuted. But what Ukrainians are doing now, they are doing pioneering work. And I want to go back a step, go back 80 years to the beginning of World War II, which I started talking about, my father. But after World War II, what happened was the crimes of genocide and crimes against humanity. They weren't crimes then in those days. There was something developed by, anybody read Lemkin and Lauterpacht. Lauterpacht was professor of environmental law at Cambridge, I think. And Lemkin was from Lviv, wasn't he?
Yeah.
Both of them studied from Lviv, that's right. Lauterpacht and Lviv ended up, Lemkin, very interesting, misread, what's it called? East-West Street.
Yeah.
It's exact. So there was no definition then, or no concept when they got hold of the ball. Two men. It was because of them and because of the Nuremberg trial that definition came onto the international statute book. So as I see it, what is happening here? Next slide, please. Where do we go to from here? What are you going to take away from coming to Cape Town? Just here. What are you going to take away in your ship? It's nice meeting you, but I'm going to challenge you. What have you taken away from your nice trip here in the summer? And one of the things is, next slide, please. So what you're doing is, I think, precedent setting, groundbreaking, environmental damage not previously considered by the ICC. These are great things to research and to take further. Developing environmental criminal law, the notion of ecocide was mentioned. So I think what you're doing, and I'm trying to do this in a national, overall perspective. I think it's a great initiative, and I'm wishing you all the best. And perhaps we can discuss these dots at the bottom further. Thank you very much, Wendell.
Thank you so much, Prof, for that tour de force in terms of environmental crimes and environmental law generally. So next up, we will have a question and answer session later on. For those of you burning to ask Prof, if there's any questions or any other speaker. So just to mention that we will have to cut not some of the discussion, but we will have to stick to maybe 10 minutes per discussion for the next participants, the next guest. So check. So our next speaker is Pascal Toulon and PJ Legal Director, former ICC Office of the Prosecutor. So we're very privileged to have someone from the Office of the former Office of the Prosecutor here. So this is a really in-depth knowledge about possibility of prosecuting crimes, environmental crimes at the ICC. Thank you so much, Pascal.
Well, thanks very much. Thanks to the University of Western Cape for welcoming us and for organizing this, and thanks to our partners from the Ukrainian Association of South Africa. Thanks very much. I mean, my colleagues will go into some details on the factual and legal conclusions of our work on investigation in relation to the destruction of the Kapovka Dam, which we want to expose and show as an example of an environmental crime that can be prosecuted as a war crime. So I will not go into legal considerations. I've been more asked to give a general introduction and to go into some policy considerations, and I'm very glad with the presentation we just heard, because basically the final slide is more or less my outline or my starting slide. So I think we are on the same page. Just quickly to say where I'm talking from. Project Expedite Justice is an international non-governmental organization. We have programs in DRC, in Sudan, in Ethiopia, and we've been working in Ukraine since March 2022, immediately after the full-scale invasion of the Ukraine territory. What we're doing is we're trying to bring accountability for communities affected by the Russian invasion, and we're working on crimes, war crimes mostly, that all have an impact beyond the borders of Ukraine. We're working on environmental crimes, and we'll expose our work in relation to the Kharkov destruction. We're also working on crimes related to the illegal stealing and what we call pillage as a war crime of the Ukrainian agricultural resources and their illegal export outside of Ukraine. We assist the national authorities in this efforts, and we work on attacks against the civilian population, destruction of civilian property and infrastructure, pillaging, and then the plunder of resources and attacks against energy infrastructures. The pillage of Ukrainian grain, this is an interesting topic. We don't have time to go into this today, but we relate it there because this has an impact as well beyond the borders of Ukraine, as well as environmental crimes do not know borders and they have impacts that spill over the borders. It's the same here with the impact on the global food security market crisis that we can feel all the way to here. What we do in terms of accountability now, which is the topic for today, is we to address impunity and to foster accountability for this crime, we support the national authorities.
Personaliannya kan ada di perumahan. Kalau udah masukin kemarin satu orang berkeringetan.
So we support national authorities, and then we try to also submit information to the ICC, and this is the case with the Kharkov destruction report that we prepared. The reports that we built based on our investigation in the field demonstrate that the criteria for the war crime of attack causing widespread, long-term and severe damage to the national environment and the Article A2B4 are met, and we will go into some details with Volodymyr about this. What we did on this basis is that we submitted it as an Article 15 communication to the Office of the Prosecutor of the ICC, and we advocated that this incident should be prosecuted as a war crime under this article of the Rome Statute. Of course, that's not an easy road. There are some discussions to have on the elements of the crime, or the definition of an attack in this case, on the way that we can demonstrate linkage with the potential authors of the case. And we know already from our initial discussions with ICC OTP representatives that this might be an issue for them, and that it might be a long road for them to be able to do it. The ICC is investigating in Ukraine since March 2022, immediately after the full-scale invasion. We know that they are working on the crimes against the environment as part of their focus. We had some discussions with their office in Kyiv and with colleagues in The Hague. It has already issued 4 arrest warrants, as you know, in relation to the situation in Ukraine. None of them relates to these crimes. They relate to unlawful deportation and transfer of population and to attacks at civilian objects. And they use the same article of the Rome Statute for these 2 last cases about the attacks against civilian objects and excessive harms to civilians. So they do it on the basis of Article A2B4 as well, but not for the environmental destruction. Of course, we believe, and that's why we're here today, that this event qualifies as a war crime of imposing an excessive, severe, and widespread and long-term impact on damage on the environment. So we believe the ICC is well placed to do it. This is exactly why the ICC was created, to address crimes that threaten the peace, security, and well-being of the world. And there are solutions existing in the statutes to address it. So that's why we are pushing for it with the ICC and our partners. All the more because, as you may know, the ICC Office of the Prosecutor since February 24 has announced that they were working on a new policy to address environmental crimes. So they have opened a consultation process with civil society in 2 phases. There was a first phase where they asked some views on environmental crimes and a systematic approach to dealing with crimes against the environment. So the civil society contributed, and then they drafted, under the guidance of Professor Kevin John Heller, a paper, a draft environmental policy, and they reopened it for consultation from civil society. And our colleagues from Truth Hunt, with some support from us, have been submitting comments this draft policy actually last week. So we're looking forward to see where it's going to go. This is a strategic approach. It's not going to change the Rome Statute. It's not going to bring amendments, but it's a strategic approach from the Office of the Prosecutor to try to evaluate the best ways to use the Rome Statute to prosecute these crimes. Of course, there are several strategic documents issued by the Office of the Prosecutor on several different crimes. It has had an impact in the past. The strategic policies on children crimes against children, sorry, have been useful in the prosecution of these cases before the office. This is showing an intent. This is showing a willingness to do something. So that's useful in that sense. Now, in terms of actual operational, practical possibilities to prosecute the Karovka Dam explosion as an environmental crime, there are, of course, a lot of challenges. Even if we put aside the initial challenge, which is the investigation of these crimes, which is very often a key difficulty, it's very challenging to access the areas, it's very challenging to identify the damage, it's very challenging to identify current victims, future victims, it's very difficult to represent the interest of ecosystems in court, but we've tackled some of this with our reports. That was one of the objectives. One of the objectives was to make it easier, at least from this side, by having a one-year investigation into the causes, consequences, and unfolding of these events. The current Office of the Prosecutor has a zero-risk policy in terms of cases that they bring to court. They are trying to be trial-ready from the beginning and to avoid risk of acquittals. I mean, I guess like any other prosecutor will do, but it means that they might not be very willing to be creative and to take risks legally. It happened in the past. During my time at the office, we took some legal risk and it didn't work very well with some of the cases that we tried to bring. And I understand this is still the case. Prosecutors at the ICC, like in national systems, would have a tendency, which is fair enough, to go after low-hanging fruits or after what's actually doable. And in this case, they might think it's a bit complicated, but it's ongoing. And if there's one thing that the ICC OTP has, it's some time. They have already issued warrants of arrest. They continue their investigations. These are not public. So we know they are working on different cases, and this environment crimes is one of them. So it's going to take some time. We don't have much time, so I'll move on to some conclusions maybe, or some next steps. Dr. Aligoun has already presented the other options available, so we not need to go on aggression, crimes against humanity, or genocide. The question of the crime of ecocide, that's open for discussion after. In this room, our colleagues from Tucson and ourselves, we are all personally in favor of moving on with this. We had a side event at the Assembly of State Parties in December where we discussed this option of the crime of ecocide being included. From a very strategic perspective at the moment, it might not be the best moment to try to push for amendments to the Rome Statute in the current international context. When you start negotiating amendments to a treaty like the Rome Statute, the risks in complicated international political context is that you get less instead of getting more. So it might not be exactly immediately strategic to push for this, but efforts should continue in parallel to actually move with this before national jurisdictions, and that's my second point in this conclusion. The ICC should not occupy all of the space, all of your mental space, prosecutorial space. There are options before national jurisdictions. Some of them were very clearly presented just a few minutes before, and these avenues should be pursued. This is the spirit of the Rome Statute, complementarity. It's all about trying to tackle these crimes at a national level, and then if nothing happens, to go to the international level. So for Karovka Dam, that's what we're doing as well. We're working in close cooperation with the Prosecutor General Office in Kyiv and the prosecutors in Kharkiv, in Kherson, the prosecutors for Crimea on this type of crimes. There is an environmental crimes working group in the Office of the Prosecutor General. We're discussing best legal options to continue, and this is something that should be done at all levels. In Ukraine, in Africa, where you have on the African continent, where you have similar cases, this should be pursued at a national, at a regional, at a local level, and then at the international level. I fully agree that international cases have an exemplary component and they help shaping national cases. In the case of crimes against the environment, I think there's a real horizontal relation where it's going to help the ICC as well to develop jurisprudence. And some of the staff, the ICC Office of the Prosecutor, are really pushing the office from inside to actually move with environmental crimes. It's difficult operationally, strategically, as I mentioned, but they are willing to do it, and they're also fostering, supporting initiatives outside of the court to do it. So there is the opening of this consultation process aims at this as well, at making sure that we can work together and build this together. So this means sharing best practices, sources, leads, trying to identify, as I mentioned, new investigative strategies, and working, and that's my last point, that's a point I really want to make from my experience in the Office of the Prosecutor and here. These crimes are connected, they are all interconnected. These crimes, environmental crimes, are connected, and that was mentioned earlier as well, to not speaking about the Karovka Dam here, to illegal exploitation of resources. They are connected to trafficking, they are connected to money laundering, they are connected to fraud, to corruption, and these are investigative tools and prosecutorial tools that needs to be pursued to actually move on with prosecuting these crimes as well. Asset tracking, this is something that's useful to bring evidence of the inputs, to bring evidence of the outputs, and to actually threaten the perpetrators of this crime, because this is what threatens them the most. It's if you go after the money, this is where the issues are. So I don't really like finishing with speaking about the money, but I think this is a really important aspect of this case. So thank you very much.
Thank you so much, Pascal, for giving us an insider's view of the OTP and what they are doing. And let's hope for some progress in the near future. Thank you so much. We can invite the next speaker. Please come forward. So we next up have, try to pronounce these names, Volodymyr Ryzhko from Truth Hounds and Miroslava Markova, also from PEJ. So they're going to talk about building the ICC case, destruction of the Karovka Dam. Thank you.
Morning, everyone. My name is Miroslava Markova. I work as investigative project expedite justice. Here with me, my very dear colleague Volodymyr Ryzhko, who works at Truth Hounds, and we're gonna just tell you a little bit about the report itself that Pascal already mentioned about the Karovka Dam destruction, and about the main, very shortly, briefly, consequences of these. And Volodymyr will provide a little bit of legal analysis also on the meaning of this report. So basically, just to provide you with very brief information, we will have presentation just in a few moments, hopefully we'll share, Okay, hoping to have it. The event itself that we're talking took place in June 2023, when Karovka Dam was destroyed. It is the dam that is located in southern Ukraine, in Kherson Oblast. Before destruction, it was critical for southern Ukraine for generating electricity, for providing water supply, and as well irrigation of agricultural lands. The breach of the Karovka Dam itself unleashed very massive flooding across large territory of Ukraine. It affected for sure both human lives and environment. We know that it flooded at least 600 square kilometers and over 80 settlements, causing a very extensive damage to infrastructure and homes. Maybe if you have heard about the event itself, you've seen these photos with people sitting on their roofs and trying to get out of the houses because it was flooded to the roof totally. The most affected part was as well on the left bank of Kherson region that is still under Russian occupation, and we don't have access to it, and we cannot talk about the full statistics of the consequences of this tragedy because we don't have this information. unfortunately. So during the full-scale invasion of Russia that started in February 24, Dam came under occupation from the very first day. And since then, Russian army was still controlling the dam itself. Yeah, this one. Sorry, just a few technical details. Yeah. Our analysis and this report, we focused as well on the one who conducted this crime, and our analysis demonstrate that the most plausible scenario is that the Kakhovka Dam was intentionally blown up from the inside by Russian forces who actually were in control of the area at the time of dam destruction. We select numerous pieces of evidence from open source, and it's evident that supporting this conclusion, it includes seismic data indicating explosions, both as well as testimonies from local witnesses, because we conducted few field missions 3 months after the event itself, talking to people who stayed in the region, talking to people who dealt with consequences, and gathering their stories and information. We also together with their testimonies of residents and seismic data, we as well have satellite imagery showing significant damage consistent with internal detonation as well. I would say that we wanted to take a bit closer look on the event itself, but unfortunately, for the sake of time, we need to shorten it a little bit. Just to name it. Yeah, thank you so much. So basically, the main idea is that yes, Kakhovka HPP was destructed from the inside, and only Russian forces had control over it at this time. Ukrainian and foreign engineers who gathered both evaluation know that a simple breach of the sluices or even the collapse of few pillars would not result in extensive destruction of flooding, as well as dam was protected from being destructed by shelling. So the only way to ruin it was technically to detonate it from the inside. Actually, there are also several elements that indicate that Russian authorities had undertaken steps before itself, during and later the destruction. First, just before this destruction, 1 month before blowing up the dam, the Russian government adopted a resolution which states that until 2028, a technical investigation of accidents involving hydraulic structures in the occupied Ukraine territories will not be conducted. And for sure, the adoption of this document indicates that Russian political and military leadership may have premeditated an attack and created conditions to obstruct any potential investigation. Second, starting in February 2023, a few months before the blowing up the dam, Russian forces began to elevate the water level in the Kakhovka reservoir, and this sudden increase in water may be consistent with the intention to generate so-called water bomb effect, maximizing the water's flow and resulting damage after the detonation. These actions resulted in flooding the areas in the vicinity of the dam even before its destruction. I will just move a bit forward to the slide where we kindly ask you also please check out our investigation and maybe look for other details if you are interested. We will be very glad to chat with you during coffee break as well. But with this note, I will need to provide Vladimir's floor to provide some information about the meaning in the legal life.
Thank you so much, Miroslava. So nice to meet everyone. I would speak a bit on the legal intricacies of this crime and this event, and how would we qualify it, for instance, under the Rome Statute and under the current framework of international criminal law. Unfortunately, I would say it is not in the Rome Statute, ICC Rome Statute, but we've talked about, and professors also mentioned the crime of ecocide, which only is planned or is advocated to be included in the ICC Rome Statute, but it's not yet there. It was developed by the 16 experts, a panel of 16 experts, which were gathered from around the world by the Stop Ecocide International Foundation. And this is like the definition of the ecocide, and I've underlined these notions of severe, widespread, and long-term damage to the environment, which are key to the environmental damage in international law. Unfortunately, in the Rome Statute, we need to look at some other provisions because we do not have this one. And this is the list of possible provisions which could be qualified for the Kakhovka Dam destruction. I would say, unfortunately, as to the ecocide, but fortunately, for the fact that the Rome Statute is the first international criminal tribunal document which mentions the environment explicitly. It mentions it in Article H2B4 of the Rome Statute, which we looked through in our report with Project Expedite Justice. It is about launching an attack in the knowledge that this attack will cause widespread, long-term, and severe damage to the natural environment. I would say here I would define these notions one by one a bit, but you will see that more on them you can find in our report. So first of all, that there is even discussion whether it was an attack because it was blown up from the inside. There were some cases in the ICC, like in Taganda case and the Almaty case, where the notion of attack was interpreted, for instance, to cover some actions which could be done within the occupied territories in terms of the cultural heritage. And here we do also advocate for the fact that the destruction of the Kakhovka Dam, it also implied and it also, let's say, influenced the other party. So it was especially the water which was coming from the dam downstream. So this is how we interpret the notion of attack, but there is an annex to our report where you can find in-depth research on this notion, I would say. Then we would have this inchoate character of the crime and the mens rea, because the wording they use in the provision is in the knowledge that such attack will cause. It does not require actually that the consequences will occur. So indeed, we may say that the risk is criminalized already in the Rome Statute of causing such damage. However, we would still need to look into some real damage because it will definitely help us satisfy this criteria, I would say. Then we have this WLS trio, which is widespread, long-term, and severe. And here, compared to the ecocide definition, it is required to provide evidence for occurring for all of them cumulatively, because they are separated by the word "and." That's a challenge, I would say, especially compared to the ecocide definition, but still, we were speaking especially with the Stop Ecocide Foundation as well, that if we do not recognize that the Kakhovka Dam meets these three criteria, then what ecological disaster one should paint in the head so it would meet these high threshold. So indeed, like I will just skip for the interest of time some of the slides, but you will be able to see them. The massive environmental consequences only are criminalized in the Rome Statute when speaking about not directly intentional damage, I would say. And the final one is the military advantage excuse, which is also within the Rome Statute provision. It is said that even though the damage should be able to materialize in widespread, long-term, and severe damage, it still should outweigh the possible military advantage anticipated. And in the Kakhovka Dam instance, and in the instance of armed conflict, it is still relevant, and the perpetrator would still try to find excuses for causing some of the environmental damage. There is some pictures and comparisons because we've analyzed two main environmental consequences, I would say. It is the flooding downstream of the dam and the draining out of the Kakhovka reservoir above. And you see the pictures here, as well as the comparison with some of the cities, for instance, in South Africa, how it would do. So you would better imagine the massiveness of the flood, for instance. Then you will see some images here. It's one of the settlements on the left bank of Dnipro before the explosion at the Kakhovka Dam, and this is after. This is all in the water. And unfortunately, we do not have access to the left bank of Dnipro River because the Russian forces are occupying it, and we do not know the exact human toll which was after the disaster, but there is investigation by some news agencies as Associated Press, and they said that only in this settlement more than 100 people died because of the flooding, but there were over 80 settlements which were flooded after the event. Then, as to the Kakhovka Reservoir above the dam and the drying up, you will see that the volume of water it stored is massive. And comparing to the biggest dam in South Africa, it is like the volume of the water is 3.4 times higher. As to the area which it covered, it is almost five times bigger than the Gariep dams and the reservoir of the Gariep dams. This is like the images shown before the dam's explosion and after, and you see how it dried up. And there are some also satellite imageries, so you will see the drying up of the Kakhovka Reservoir. As comparing to some, for imagination, it's with the biggest lakes in South Africa, it would encounter for 5 Saint Lucia lakes, which were dried up after the destruction of the Kakhovka Dam. So, coming more to the legal conclusions and how we cooperated, for instance, with experts in ecology. What we found from our legal analysis perspective is that we could really well cooperate and join our efforts to prove, for instance, the elements which are required by the provision relating to the crime. So, for instance, we explained to the experts with whom we collaborated, what notions should we look at? So we explained that the widespread notion would relate to some number of kilometers squared, but it would be best to have some 100 of kilometers squared to satisfy this criterion. Then as to the long term, it would require decades. These notions are taken from the additional protocol 1 and the commentaries to it, where we look at them. And the severe would relate, for instance, to the fact how it affected the local communities and how it affected the environment as such as well. So we helped identify and highlight these environmental requirements, and they would then look through the specific damage which could qualify and could satisfy all of these 3 criteria. And for instance, with the water and with the drying up of the Kakhovka Reservoir, we collaborated with a certified hydrological expert. And she estimated, for instance, that there was a loss of groundwater because of the drying up of the Kakhovka Reservoir. And she estimated that it will take up to 33.5 years only to restore the levels which were before the explosion at the Kakhovka Dam, which shows the long-term impact of the destruction of the Kakhovka Dam for sure. Then, these long-term criterion is also highlighted, for instance, in the United Nations Environmental Program report, which also was produced just several months after the disaster. I would briefly mention the consequences for the Zaporizhzhia nuclear power plant because it's the biggest nuclear power plant in Europe, and here with South Africa as the only country in Africa which has a nuclear power plant, this aspect could be also interesting for you. So the fact was that the Zaporizhzhia nuclear power plant was premised to and was licensed to operate only upon the existence of the Kakhovka Reservoir, which is gone, as you see. And now it is gone, and the biggest problem is, there is a slide on this dependence, and the biggest problem is that the Russian military now are occupying the Zaporizhzhia nuclear power plant, and they plan to restart the reactors, because now they are in shutdown mode, which is the only reason why there was not a nuclear catastrophe after the destruction of the Kakhovka Dam, because they do not use so much water from the cooling pond. But yeah, this risk of possible restart is alarming. And we had also some meetings with nuclear specialists from South Africa to underline the possible risks of operating nuclear power plants, especially in times of armed conflict. I will then go to two final elements, and I will end here. But one of the things we also analyzed, apart from environmental consequences, is this military advantage excuse, which is written within the provision of their own statute. So when we analyzed, we also contacted some of the military experts, and our collaboration with them was also crucial in terms that we explained some of the legal notions we need to, and they provided us with the expertise from the military point of view. So as you remember, the provision says that a military advantage could override the environmental consequences. And what we've tried to is to measure this military advantage gained by the Russian occupying forces, which blew up the dam. And what we found that actually there was not so much of the military advantage which they obtained after the destruction of the Kakhovka Dam. One of the main reasons is the fact that the dam was situated on the front line, and on the right bank of the dam there were Ukrainian forces, on the left bank there were Russian forces. After the destruction of the dam, because of the elevation, the left bank of the dam is lower compared to the right bank of the dam. And this is why actually the Russian forces, even one can say, suffered more because of the flooding, because the left bank of the dam was flooded even more than the right bank of the dam. The only short-time military advantage that could have been expected by the Russian forces was a temporary flooding of some of the islands, which were situated between the right and left bank of the dam, and which were occupied then by the Ukrainian armed forces. But it is a short term because in 4 to 6 weeks after the destruction of the dam, the water level receded, and the Ukrainian forces were able to come back to occupy these islands once again. So when we speak about this military advantage and environmental damage, one should see that the military advantage gained by these attack on the Kakhovka Dam was miserable, while the environmental damage was really huge. And when compared, the environmental damage would surely override the any military advantage anticipated in these circumstances. So to the knowledge of the consequences, I would invite you to also see our separate annex, prepared also by Miroslava and one of my colleagues, as to the statements by the Russian officials, where they explicitly recognize the massive environmental consequences which would occur if the dam is destroyed. So they knew that this could lead to environmental disaster, but still proceeded to blow up the dam. Thank you so much, and you could access the summary report.
Thank you so much, Vladimir and Miroslava. We appreciate sharing with us some of the environmental damage in Ukraine. So it's clear for us to see. We can also go outside during the break, which will happen now, to see some of the photographs that you've displayed in the passage. We can now stretch our legs for 5 to 10 minutes, and there's some coffee and tea outside. Thank you so much.
That's what I said. That's the problem. Like, I don't know, I don't. So I can't really think of it. This is the second time.
Way you collect and acquire the information about crime. Let me give you some more specifics to make it even more illustrative. So, for instance, with Kakhovka dam destruction, there are several legal strategies how you can pursue the case further. The one legal strategy would be to say that the attack on Kakhovka was an attack on civilian objective. If that's the strategy that you are pursuing, then you have to show that Kakhovka was the civilian object at the time of the attack. If it was a civilian object, then you have to basically prove that in military sense there was no big gains for the opposing army to bomb, attack, or any other way destroy Kakhovka dam. So that's this type of thinking requires certain type of evidence, the evidence of military activities nearby the dam, some considerations of the law, what it says about the dams itself, whether they are of military nature or of civil nature, whether of mixed nature, and if so, how we assess the status of the object in the time of the attack, the time when attack occurred. And then if you go with this qualification, you don't really need information about the environmental damage. So you will probably need it just to say that the violation of the laws and customs of war caused certain damage to environment, and this damage is not an element of the crime, but rather the consequence of the crime. And you need to know this damage only to maybe ask the perpetrators who will be established guilty to compensate for those crimes. So that's the only way, only a reason for which you need information about environmental damage. You can go with other strategy. For instance, that might be a strategy of destroying enemy's property without military necessity. So for that, you don't need even to prove that attack occurred. So that is irrelevant for the qualification. What you need to prove is that there was no military necessity in destroying the property. And that's something that a bit echoes what Volodymyr was showing you, the consideration of military gains that could have happened if the dam actually that happened in our case, if the dam was damaged or completely destroyed. So that's the only thing again that you need for this qualification, the military necessity, not the environmental damage, not the attack as such, but rather the military necessity gain. Environmental damage you may study, again, just to put the right to check to the accused who will be found guilty. You can go with other strategy. You can say that the dam was destroyed for the starvation reasons. Then you have to prove that the dam was destroyed with a special intent to destroy agricultural goods downstream from the dam. And then you have to show that those who planned and perpetrated the destruction of the dam knew about such motives and actually had such motives when they acted against the dam. It's a very complicated route, but in principle, in theory, it's possible. Again, for this route, you'll need specific types of evidence. You will need some environmental damage evidence, but only those that have to do with destruction of artificial part of the environment, meaning agricultural fields and agricultural goods and territories. So again, you see that with this strategy, you will have to collect and qualify such an evidence in a very specific way. We decided to go with a different qualification, and that the qualification that Volodymyr described to you, that the qualification on the Article 8.2b4, that the only article of the Rome Statute that directly mentions environment and directly deals with environmental damage. So in this, when we do this qualification, we actually need to consider environmental damage, not just for the reasons of writing a check, but for the reason of building the case, because environmental damage is an integral part of elements of this crime. But the question still, whether the environmental damage itself or the desire to cause environmental damage. Because 8.2b4 crime is what we call an inchoate crime. That means that the results do not matter. What matters is the intent of the perpetrators. In this sense, what we really need to establish is what damage the perpetrators or organizers of the crime wanted to achieve through the destruction of the dam. So you see again that this very much shapes the way you collect evidence and you plan your investigation. If damages do not that matter, but the intent matters, you should better concentrate on the examining of, for instance, statements of different political or military leaders who spoke about the potential causes or potential effects of the destruction of the dam. Again, damage for the environment will matter for the check writing, but also for some reality check, whether the expectations of the damage were real or not. So for that, for checking whether the expectations of the perpetrators regarding damage to the environment were real, you need to study the damage itself, the damage that really was caused by the blowing up of the dam. So here we arrive to the place where we indeed need to study environmental damage that was caused by the dam, and that's where environmental damage really starts to matter for the prosecutorial investigation strategy of the 8.2b4 crime, war crime against the environment. But the questions do not end with this, because there is another question. The damage that is being caused for the environment should be simultaneously widespread, long-term, and severe. And that means that when you evaluate the damage for the environment, you should not just see how much this or that ecosystem suffered from the attack. You have to always keep in mind that any type of damage caused by the attack should be evaluated through this lens of either severe, either long-term or widespread or severe. So in this, basically every damage should be considered whether it is one of, not one, but altogether corresponds to these three criteria set up by the additional Protocol 1 to the Geneva Conventions and Rome Statute. How to do that? There is no international practice of evaluating damage through these three lenses. And therefore, you have to first, while doing investigation, you have to first come up with the definition of what widespread means, what long-term means, and what severe means. And that's quite a complicated task. But even apart from that, you have another task to achieve. And that's the task of answering the question whether every particular type of damage should be simultaneously widespread, long-term, and severe, or there might be some type of cumulation. So when one damage is not that widespread, but quite severe, and then other damage is also not that widespread, but quite severe, but it's in the different pocket, so it's in some distance from the first damage, right? And then all of them together are widespread, long-term, and severe. So whether it's a possibility for you when it comes to investigation and prosecution of the crime, would it suffice to show that the pockets of damage together are widespread, or every particular damage should be widespread? So that's a complicated question that you have to answer in the very beginning, even to be able to properly collect evidence of this damage. We, in our investigation, we approached this issue with the idea that the pockets of the damage is enough to show, if they are altogether widespread, is enough to show that the widespread criteria is met. And then with long-term and severe consequences, we also kind of gave our own definition that is based on law, based on the commentaries to the law, but still it's innovative in many senses. For instance, with long-term, we said that we accept that it might be required to show that at least 30 years damage is caused, but at the same time, we also say that if certain representatives of certain species of flora or fauna are distinct as a result of the explosion on the dam, then we consider this damage long-term by definition, because there is no way of returning to the way it was. Also, when it comes to the destruction of ecosystem, the destruction of ecosystem also automatically meets the criteria of long-term damage, because you can't rebuild ecosystem as it was, like 100% as it was. It may rebuild to such an extent, but not fully. With severe, it's even more complicated because there are no definitions on international level, absolutely no definition on international level what severe means. There is definition in the ecocide proposal, but it has nothing to do with the idea of severe enshrined into the Rome Statute or additional protocol 1. So basically, we kind of combined the ecocide definition with some consideration that we had of our own, and that's how we came up with the idea of severe. And we basically say that severe means also, among other things, impact on human population that lived around the ecosystem that were somehow impacted by the explosion on the dam. So that's our approach to severe. And again, every definition that we gave to every of these three criteria meant that we should collect and store and organize evidence in such a way. And then probably, since my time ran out, I will finish with one last complication that we faced. And that complication on the prosecutorial side. So we worked in some cooperation with prosecutors, meaning that we informed them about the results of our investigation to facilitate their investigation. And that's now I'm speaking both about the domestic prosecution and international criminal court. And one of the problems that we identified was the temptation, basically, of the prosecutors to ask scientists who logically knows everything, whether certain damages are widespread, long-term, and severe. So we saw documents signed by prosecutors with this particular question, whether damages are long-term, severe, and widespread. But frankly, those concepts are legal concepts. That means that scientists have no tools to answer that question. It's only prosecutors or lawyers who can answer based on some material, some substantive information gained from the scientists. So basically what scientists can do is to explain in the scientific words what is the damage, how the damage impacts ecosystem, how big the ecosystem is, how many years the ecosystem will need to rebuild, how many years certain groups of species will need to return and restore their population. So that's types of questions that scientists can answer. But whether the damage is widespread or not, that's the issue that only prosecutors and lawyers can address. So that's also something that one should be aware of, that there will be always temptation to all rely on scientists and oversimplify the work for lawyers, but that should not be the case, because that would fail in the court for sure. So I will stop here, but I will be glad if we have some discussion afterwards. Thanks.
We actually do have a session open for discussion now. Maybe it would be good to invite the speakers to come sit in the front, even if we put a chair here and another chair there. We have about 25 minutes, I'd say. We have to finish before 1. But we do need at about 5 to 1, we need to end with just a word of thanks and closing. So yes, let's wait for everyone to. Thank you for all of these insightful and fascinating discussions. I think what is apparent to me is the intricacies really of international law, international criminal law, and international environmental law. And the discussions today really highlighted for me some of the challenges and maybe reasons why we haven't seen a prosecution for environmental war crimes. But it also gives me hope because there is development and there is debate and there are people, important people, or people doing important work on this topic. To my mind, several questions arise, and I'm by no means an expert in international criminal law. So I'll give some thoughts and then open up the floor just in general. We don't even have to discuss my thoughts. But some of the thoughts I had is, I think on the last point that you raised, Dimitri, is on the legality, the legal definitions. So if we wanted to prosecute environmental war crimes as firstly a war crime in the Rome Statute, we'd have to prove intentional, which I mean should be easy to prove, but how and to what extent what is the threshold for proving widespread, for proving severe, and the last part of Article 8.2, which says which would be clearly excessive, because a war is already excessive. So is there a difference then to, how do we prove that? Do we look at environmental sciences, for instance? Is there a guideline for proving that? Another question I had is, if we think about declaring this or prosecuting this as a crime of humanity under Article 7, there is a clause there that says, so causing suffering or serious injury to mental and physical health. In the South African context, at least, the environmental right is linked to your mental and physical health. Even if you can prove that you have severe anxiety because, for instance, of a climate disaster, or anxiety or depression because of the environmental conditions. So is this something that could assist in proving that this environmental war crime, can we put it under that banner, under Article 7? How does it link to, or what would we have to prove to say the environmental damage has impacted our mental and physical health? Then another thought I had was under Article 8, looking at war crimes again, maybe if we could argue that the enemy has used poison or poisoned weapons, and if that has poisoned environmental resources such as water, is that a possible means to strengthen the argument? Another one that I thought under the same clause is intentionally using starvation of civilians by depriving them of objects indispensable to survival. To my mind, that includes water, and that the destruction of the dam is strongly linked to that. So is that a means of strengthening our arguments, at least in front of the court? And then, of course, we need to think about the role of international environmental law principles. Do they have a role? Can we strengthen their role? I think the fact that we're speaking about ecocide is an important development, but as you mentioned, it doesn't yet have teeth. How can we give it teeth, I guess, if it's not yet going to be recognized in the Rome statutes? And then, Dimitri, you ended on legal strategies, and you gave quite a few. So maybe we can speak about which strategy would be the best or have the most weight, although I suspect it depends on the merits and the evidence and the fact. But those are my thoughts. Please feel free to add more thoughts or questions, and let's see what we can discuss in the next 20 minutes. We do have any questions. Yes, maybe we should collect a few questions and then we'll do a round of discussions and Slide, you can keep an eye for me on the comments if there are any comments or questions online. All right.
The big question for me in the criminal case is who's the accused?
What else?
That's from my side to abuse as the ex-chair, my authority. So what about the current arrest warrant against Putin and Maria Belova? So we have those arrest warrants, but of course the implementation is problematic. If Putin stays in Russia, he'll never be prosecuted, we know that. So my question to you, Pascal, maybe, or anyone, why do we care? So that's just why are you passionate about this? Do you think it matters? That's the question. Because I think it matters, but what do you think? Yes.
Good morning. My question is essentially based on the principle of sustainable development. How can we use that principle, especially when we were discussing earlier how when the dam was damaged, it would take, I think, 33.5 years to be refilled. And the part of sustainable development that particularly focuses on present and future generations, because it seems that environmental damage and destruction particularly harms future generations and not just present generations.
Quite a lot of questions. Maybe we can start addressing them. So I will start with the one question regarding how science can help us identify whether the damage is excessive in relation to the military necessity, military damage anticipated, right? That was one of the very interesting and complicated question, frankly. Unfortunately, there are no scientists who can actually compare those two things because just to use a metaphor, it's like comparing Cape Penguins and South African national rugby team. You can't really compare them. So damage and military necessity are completely different beasts. So you have to do it yourself as a lawyer, and you have to see whether the damage is indeed meets those three criteria, and whether the military necessity is so big that it can somehow be greater than the damage caused. Usually it won't be the case. Usually if you meet three criteria, that would already kind of semi-automatically mean that the military necessity can't in any way be compared to the damage. But sometimes, for instance, if you end the war with this type of damage and you win the war with such type of causing such type of damage, that might theoretically be an excuse, and theoretically again it can lead to the absence of the case for the prosecutors. So that's my answer, but yeah, it's no answer basically. Anyhow, with some other questions, who are they accused? There was the question. I think that it very much depends, and very much depends on the mens rea element of these crimes. Because with war crimes in general, and in particular with war crimes of disproportionate attacks, the hardest thing to prove is the mens rea, the intent of those who either organize or perpetrate the crime. Usually you do not have evidence of the intent of the direct perpetrators. Because they do not write down what they thought, because they do not have, share their idea of what, they don't have even the intelligence to compare the anticipated damage and military necessity. So they usually, intelligence, I mean the information from the intelligence agencies. So for that reason, very rare you will see the case against direct perpetrators when it comes to the attack-related crimes, especially to the disproportionate crimes. But in case of Kakhovka, is unique for the reason that the information about the damages was widely shared by civil occupational administration and military leadership of the Russian Federation. So basically, this information was available to anyone. Moreover, we have the video capturing a couple of soldiers of the Russian Federation that are discussing the potential damage after the potential breach of Kakhovka Dam that happened half a year before the dam was actually blown up. And on that video, Russian soldiers discussed how severe would be the consequences. So that shows even a regular soldier would not have understood that damage will be excessive in comparison to military system. So in Kakhovka case, we actually can go against direct perpetrators and also higher-ups, but usually only higher-ups will be the response. I think not to maybe occupy the mic for too long, I will share it with someone else who wants to address.
I mean, the easy question about the arrest warrant, I can address. Just on building on this, for this type of cases to find the accused, I mean, the ICC will not go for the lower level perpetrators. It's an additional level of difficulty. They will not go after one member of the 205's motorized rifle brigade, for instance. Unlikely. They might. I mean, there's different prosecutorial strategies. One is to go up the chain and start with the direct perpetrators if you have a chance to go higher later. If you just go down the chain, then what's going to happen is that you're going to be heavily criticized for this unless you are sure of winning, and this will have a groundbreaking impact. So that might be the case if you are the first ever environmental crime case under Article 82b4, and then you manage to demonstrate that the head of that one of the local commanders indeed is clearly responsible. That might be the case, but that's a lot of might on the way. And I think the linkage elements, we are not, as an NGO, and however hard we work, we are not in a position to go all the way to beyond reasonable doubt on behalf of judicial authorities. We don't have access to intelligence. We don't have access to comms. Comms are very important in this type of cases. You have people speaking. We have some information in the report. We have some elements that say that there were visits of higher level people, including higher level political and military command to the region a bit before. So there are some elements, but these are not enough to go this way. That's a long work. Now the existing warrants, I'm not sure what to answer. Yeah, it's important to implement these warrants. It's complicated. These people, I mean, Belova and Putin are probably. Belova, I don't know personally to the extent to which she's leaving Russia. I don't think she's leaving Russia that much. What the Office of the Prosecutor and the Registry of the Court are doing is to monitor the movements. They are collecting foreign intelligence about movement when foreign intelligence is available, which is sometimes the case and sometimes certainly not the case anymore. So that also depends on this. Arrest for warrants of arrest at the ICC depends on 85 to 90% on the goodwill of the states to execute their obligation to cooperate with the court. If you have information about movements of people, if you are in a position to trigger action by states where these people are gonna go, then you have a chance. And that happened a few times at the ICC, but there's an obligation under Article 86 for states to cooperate with the court, state parties. But we saw with a trip to Mongolia in September that sometimes this obligation is not implemented, and then you have big change of political agenda. It might very well be that President Putin travels to other places in the coming weeks or months without being arrested. But we'll see. What we have to do in this is to maintain consistent approach by state parties to the ICC, including South Africa, including all of them, Ukraine now, to actually every time bring all the possible, follow all the possible legal avenues to make accountable those who welcome people under arrest warrants in the territory of state parties. So of course that's the case for President Putin. If he travels to any state party, there should be every time civil society, legal action, international campaigns to stop it or to arrest him.
Yeah, if I may then jump in the discussion of some of the legal interpretations and alternative qualifications, as you mentioned, starvation, ecocide, crimes against humanity. But first I will start with this clearly excessive notion and comparing damage to the military necessity, which already which also commented. I just wanted to highlight that this word of clearly excessive was added indeed only in the Rome Statute. It is not visible in the additional Protocol 1, from which Rome Statute also was inspired by, let's say. How they commented on that, because it seemingly may raise the threshold, right? But however, some of the commentators, they still make an argument that it does not so much raise the threshold, rather than it indicates for the International Criminal Court that it would take upon only those cases which are clearly like excessive and which are like visible, their, let's say, destructiveness of the consequences is visible much more than in other cases. However, it would not raise the threshold per se. So it's more like for the investigative and prosecutorial strategy on which cases to pick up, and also makes a link with this gravity threshold from the Rome Statute, which is also exists for any crime in the Rome Statute. So that could be an argument that the threshold is not so much raised. In terms of the legality principle, I would say in these notions of widespread and long-term and severe, there is also a lot of discussions about this, because some say that we could not prosecute because we do not have clear thresholds, right? However, it's not new for the international criminal law to use such terms which do not have an exact definition. And that's also natural for international criminal law to leave some of the space for some of the terms, because you could not anticipate all of the instances which could occur. So for instance, in the notions of the crimes against humanity, there is the notions of widespread and or systematic attack, right? There is also no exact definition. However, it does not bar the court to indict and charge people with the crimes against humanity and to provide interpretations of these legal terms within its judicial practice. So the same could go with the notions of widespread, long-term, and severe. And that makes maybe a link with crimes against humanity and with the Hafkada. I would say it could be looked through this perspective of the injury, physical or mental, for the people. For sure, the only fact that we would rather go, there are like these higher requirements to prove, compared to the war crime, I mean, to prove that the attack was either systematic or widespread, right? We do not have these in the war crimes provisions, but with the crimes against humanity, I guess the Kahokadam could feel at least in the widespread notion, if not systematic, because it's a one-time act for sure. Then as to the starvation and water, the only problem here would be, I guess, with the intent. Because, once again, because we will need to prove that the attacker intended to starve the people, not just to deprive them of the water or of the means of the food. That could be an issue. And yeah, if you're talking about perpetrators, I also wanted to add on who's the accused. We actually have in our report in section 2 the methodology of how we identified a specific unit of Russian army who was occupying the plant and who controlled the plant at the time of the explosion. So this would hint us that we could look in that direction as to the management of this army unit, of this brigade, and we identified the commander of this brigade, and he's mentioned in our report as well, and that could be the link to the identity of a person, let's say, who is in charge of this crime. I will just add two more things as to the starvation of water. As I mentioned, I wanted to make a link to the question of the sustainable development, because indeed, for future generations, there could be some great implications. And actually, maybe I'll just give a floor to Dmitro, maybe to comment on the findings of the colleague from the Hague as to the care, right? Because yeah, you know a bit more on this.
So just to start with some general remark, following what Volodymyr was saying, I think that the whole idea of this Article 824 in the Rome Statute is to somehow implement the principle of sustainable development and protect a little bit at least the rights of future generations. But frankly, this article is also built on the additional Protocol 1 provision that protects environment, and that provision back in 1977 did not necessarily take into account the sustainable development principle because it was not a big issue back then in 1970s. So again, there is some link, but not sometimes not that intentional. Anyhow, there is indeed impact on future generations of any environmental crimes, and I think that the brightest way to show this connection is through the criteria of long-term impact of the act or the attack on the environment. And what Valdemar was referring to, one of the research that was commissioned during the investigation of Kakhovka Dam disaster was the research conducted by the Italian scientist who took the samples of hair from the people who attended the beaches right after the catastrophe on Kakhovka. And Kakhovka is not only about flooding, it's also about spreading some chemicals that were nested on the seabed of the Kakhovka reservoir, and after the blowing up of the dam, they were spread along the shores of the Dnieper River. So basically, the idea of his research was to see whether these chemicals ended up in the bodies of people who were on the beaches, and also to see how this impacts their health afterwards. So the first step in that research was indeed to take samples from people, samples of hair from people, and identify whether some chemicals are there or not. So that research is ongoing. It's not done yet, kind of finalized. There are no final conclusions. But that's one of the hopes how you can actually show that future generations are indeed impacted by the events from the past, especially by environmental disasters of the scale of Kakhovka.
Thank you. So I was inspired during the whole seminar about maybe South Africa should start bringing a case on environmental damage. And my remarks are just based on that. But to come back to sustainable development, which came from the back there from my new Namibian friend, just to add, is that as I showed, the interaction between international law and domestic law in our NEMA, and I must emphasize this, it defines sustainable development, and then it says sustainable development in section 4. If you're a student here, you must look at section 4 because it says the following principles apply to develop sustainable development, and that is precautionary, all those principles that are listed. Another remark that comes to my head is, again, I'm reminiscing because when Dimitri spoke about the facts, I went back in my head about 30, 40 years when I was an article clerk and a walked-in young guy, and the senior partner said to me, "You come here with your fancy law degrees, your whatever, masters." He says, "There's only 3 things important in a law firm. Number 1, the facts. Number 2, the facts. Number 3, the facts. That's what you need to know." It's a very important point. And I was, really gratified to hear about how difficult it is, and also to strategize about how you're going to develop the facts, because it's really illuminating. Thank you. And then to come back, as I said at the outset, I thought, what could we do in South Africa? Because as I'm saying, keep on saying, there's a complete, interaction between the international. Who causes the most environmental destruction in South Africa? We're going to ask the students here. Who's the most naughty environmental destructor in South Africa? Is it the Defence Force? Which industry is causes the most environmental damage? Sorry?
Private, like Shell, corporate.
No, the mining sector. The mining sector. If you go to the rural areas in the north, it's terrible what they've done to the traditional communities that have been living there for years. The mining sector has devastated the waterways, the river systems, this pollution, illnesses, the energy and mining sector. So then I thought, I could maybe take a case on the environmental sector, damage in the mining sector. But actually, there's already cases The Center for Environmental Rights in Observatory based here has taken cases against the mining industry. Not by them, but another law firm has taken the asbestosis case against them, damage to health. So there's asbestosis. Did mining in the asbestos mines in the Northern Cape cause lung disease and death? So that's again the causality question. So this is an area ripe to bounce off, in the international context. So I think I've just covered what I wanted to say. Thank you.
Thank you, Prof. I just want to give an opportunity to anyone online. Do we have online comments?
Yes, we have 2 questions online.
All right, and also just to give an opportunity to Dr. Adigan in case he wants to say something. Should we read the comments online or?
Okay. Thank you. Can you all hear me clearly?
Yes.
Okay. I think the question that is relevant to me here is there political will to criminalize ecocide in Africa, say at AU level? Then what are the prospects for a regional convention? And then the third one has to do with, do we have many examples of acts that could meet the widespread, long-term, and severe threshold? Okay, let me start with, is there political will to criminalize ecocide in Africa, say at AU level? Well, if you go by the 2021 definition of body of experts on the meaning of ecocide, well, I will say there is no political will in Africa to criminalize. Hazardous waste. Like trafficking in can you hear me, please?
Yes, you're back.
Oh, great. Like trafficking in hazardous waste. Yes, that is contained in Malabo Protocol. And then if you look at African Criminal Court, which is being proposed, so I will say trafficking hazardous waste, then illegal exploitation of natural resources. There is political will to do that, even though apart it is yet to take effect. Now, what are the prospects for a regional convention? Well, the prospect so far is with respect to the proposed African Criminal Court, where there are so many problems with the proposal at present. It is combining about 3 jurisdictions together, one on human rights, one on international crime, and then I think the other one also has to do with international maritime law or something like that. The position of most scholars is that for a single court to combine all these 3 is not going to be easy. And in the end, it may not be effective. But that is one that is in the pipeline. In my paper, I argued that, well, we may start considering regional courts. ECOWAS court, maybe ECOWAS court is very effective in West Africa. Maybe it can be given criminal jurisdiction. The same with East African Court of Justice. In fact, East African Court of Justice is very much daring because it wasn't given human rights jurisdiction, but it decided to take it up on its own. And the most East African states have not found it easy, but the court is very daring. But it is a bit different when we are talking about criminal jurisdiction. It must be specifically given to that court. So that is as far as the prospect is concerned. Yes, SADC tribunal, it has been defunct, but I think South African leaders, I'm not talking of Republic of South Africa alone, leaders in Namibia, Zimbabwe, and the likes, maybe they need to put their house in order now and then be much more serious in prosecuting crimes against the environment. So SADC maybe can be revived. Then the last one, do we have many examples of acts that could meet the widespread, long-term, and severe threshold? I think so, but I'm not so sure. But in Nigeria, for example, I know we have activities of Shell Petroleum Company in the Niger Delta is one example. It is widespread. There's no doubt about that. It covers several thousand kilometers. Long term, yes, almost 20, 30 years now. So that is met. And severe, of course, it is severe. People could no longer farm. People are dying. Yes. So it means it. But there's a problem with prosecution. How? For example, if it relates to individuals, an activist of 30 years ago, you can't hold the chief executive officer of Shell now responsible for what happened 30 years ago because it's individual criminal responsibility. The person will just say, I didn't do this 30 years ago. I'm just CEO 2 years ago. How could you hold me accountable for that? The only way out is most probably to hold Shell itself, apart from individuals, to hold Shell itself criminally culpable. So that means what happened 30 years ago and which is still continuous, Shell, because it remains Shell. Shell 30 years ago is still Shell now. So Shell could be held culpable. But individual criminal liability, somebody is CEO for 5 years will only be held accountable for what happened within 5 years. And for what happened about 30 years ago, it's possible that even the CEO at that time might have died. So these are some of the challenges. Thank you very much.
Thank you, Dr. Adigan. We have really run out of time, so unfortunately I can't take further online questions. I'm going to give our colleague from the ACCTJ, Linda, an opportunity to come and give just closing remarks. And then just a final little announcement from us. We would like to take a group photo of all the speakers in the room where we had tea. And there are some light refreshments at the end of the event as well for those of you who can stay. But from our side at GALC, thank you so much for all of the participation, and I hope we can continue these discussions and perhaps form a partnership as well. To you, Linda.
Thank you very much. My name is Linda Mushariwa. I'm a researcher at the African Center for Transnational Criminal Justice, and I teach the International Criminal Law module in the master's program. I am giving this vote of thanks on behalf of our director, Prof. John Mark E., who could not be here with us today. I just want to thank everyone who made time to attend this very important conversation today, both those who came in person and those who attended online. I want to thank our administrators from the two centers, Ms. Debbie Gordon and Ms. Tracy Ann Oliphant, for ensuring that everything goes well today. Our directors, Prof. Angela, Prof. John Mark, and our able moderator, Prof. Wendell, our IT team, Lansha and his team, and Jinka and the delegation from Ukraine. Thank you very much. Thank you for coming to engage with us. We tell our students in the ICC that international criminal law is not an isolated branch of international law. And I think that today was a perfect opportunity for them to witness in practice that there is an interplay between international criminal law, international humanitarian law, international environmental law. Thank you very much. We have some organizations, I think, from Ukraine that are present with us, Truth Hounds, Ukrainian Association of South Africa. We also have Project expedite justice. Thank you very much for coming and being with us today. We have come to the end of the program. There will be slight refreshments outside where we had our coffee break. And also, importantly, we have flyers there. I also forgot to mention Dr. Steenkamp from the Global Environmental Law Center was seen to the poster. And there are pamphlets, the flyers. Please feel free to take for yourself, your family, your friends, your colleagues. There is a lot here. Thank you. Yes, some of them are outside and some of them are here. So there's not a minute.
No, thank you for taking care of. Well done.